afternoon, Your Honor. Cheryl Luckoff on behalf of the plaintiff.
Good afternoon, Your Honor. My name is Leon Boykins, and I'm a student attorney with the Michigan Civil Criminal Litigation Clinic, requesting permission to appear on behalf of Ms. Casey Actons under Michigan Court Rule 8.120.
Permission to practice is granted.
Thank you.
All right. What are we doing?
Your Honor,
good.
it's their motion, so I will let them argue it. I will restrain myself at this moment from any argument.
Okay, go ahead. Go ahead with your motion, counsel.
Okay, so today we are here to argue the merits of Atkins' motion to set aside the default judgment that was entered against her. We believe that she has good cause, as the last appointment was missed because Ms. Atkins, as a single mother, had to take care of her sick daughter on the day of the hearing. And during the hearing, she was in contact with the court clerk, trying to alert her of her situation, and has since tried to reschedule the hearing, as her defense has no.
She was in contact with the court clerk, how?
Email and by phone.
Okay, go ahead.
Yeah, and additionally, lastly, we think that she has a meritorious defense, as this past January, she was without heat for 3 weeks, and once in which building management instructed her to try to fix the problem herself by consulting YouTube and to also heat our apartment using her oven. So as of right now, we are trying to reinstate the case so that we can come to a fair agreement between both sides.
Is
Your
that
Honor.
when you're saying she withheld rent because of that?
No, we are saying, yes, we are saying that.
Okay. Ms. Luckoff.
Your Honor, first and foremost, I have a motion filed by the defendant, which nowhere states anything about heat. Okay, so this is not an issue before the court based on the motion filed. Number two, the tenant was given a credit for any heat issues. Number three, what was presented to the court actually was that the defendant had filed for rental assistance, that she missed her court date or whatever the reason, and we can even stipulate possibly that there's good cause. But the meritorious defense that was presented to the court was that there was rental assistance pending. This initial hearing was on February 9th, and even if she did have pending rental assistance, which I don't have any documentation of, but she indicates she provided it to the court, the month is up. So if the court is inclined to set aside a default, I would ask to enter a judgment today, because today shows $4,178. But I don't believe she meets the meritorious defense. They're now telling us about heat, which again was not part of the motion and was previously addressed with the tenant. And I would submit she's clearly, she moved in October, she paid 2 months rent, and then she hasn't paid rent since. So the last rental payment received was on December 2nd. And I'm just looking here to see when this credit was provided. It was provided after she brought it up to the landlord, actually in February. But at this juncture, Your Honor, I'm asking for the motion to be denied, and a writ was filed on this. So we'd ask to go forward with the writ.
Why in her motion, counsel, doesn't it say anything about heat?
We just believe she didn't understand the correct legal standard, and the motion, as you'll see, was actually just an email from her to the court. And so now we are just trying to, gather all the correct facts and argue the case properly.
Well, it doesn't work that way, respectfully, Your Honor. I mean, this was what was presented as a motion to the court. And if there was a heat issue, certainly that would have been foremost on her mind when she was filing this motion. This to me is a stalling tactic. And again, rent not being paid since December. Was any rent put into escrow, Your Honor?
Well, that's what I was just looking. You have anything in escrow?
No.
No, I don't even have. So I'm not even sure how this got before me. there's nothing in escrow. She didn't even post 1 month's rent to stay anything with the court. She doesn't say anything about heat. She also, in her email to the court, it's a bit unclear. She requested a Zoom hearing was approved due to her daughter being extremely ill and taking her to the doctor. I was communicating with the clerk through email and was on hold for over an hour. I was taking my daughter to the doctor and she had to have an x-ray. My phone died. And then she said requesting another hearing so it may be heard. And I'm attaching a copy of my doctor's note, which I'm not even clear that I have that.
I did not receive a doctor's note.
Yeah, I don't even have, guess I don't want to say it's not here. I'll look through every piece of paper, but I don't even have a doctor's note. She said she was attaching a doctor's note. I don't even have a doctor's note that she says is attached via her email. As I indicated in that, she doesn't say anything about the heat. She doesn't say anything about her withholding rent for some other reason. She doesn't say anything. And she didn't post 1 month's rent to the court rule to stay the proceedings. I'm not even sure why she wasn't there because I don't even have a note, which I would normally have from the clerk's office, that she contacted the clerk's office. She also hasn't attached, she says by email. I don't have any emails from her to our clerk's office or to the court.
Your Honor, if I may, through my communications with Ms. Atkins, she has told me that she will be able to provide documentation of why she wasn't there via doctor's note. And
yeah, but the hearing's today.
understandable. I mean, she's also present with us on Zoom today and can maybe also speak to why she was unable to provide the doctor's note up until this point. And it was I was under the impression that she didn't go into the meritorious defense because she was dealing with her family in the hospital and was just trying to reschedule the hearing.
Well, she's asking, the hearing couldn't have been a reschedule because the hearing was on the 16th. The document that she sent to the court, the only document I have is the 23rd, so almost a week later.
Okay, and from my understanding, the health problems with her daughter unfortunately are reoccurring, and there have been multiple appointments that have required her attention.
I'm not doubting any of that. I'm just saying that I get something on the 23rd saying that she was in the taking care of her daughter at the doctor's office, going to provide documentation regarding that. I don't have that documentation. I'm now, that was on February 23rd, and I'm now 2 weeks post that. I don't have anything. There was not a month's rent posted into escrow to stay any proceedings. There's no mention in this, even a week after the fact, about heat or whatever other type of meritorious defense you're bringing up. I have nothing. Quite frankly, I don't even necessarily have good cause for failure to appear because I don't have anything that says why she wouldn't have been available February 16th to appear before the court. So without anything else that had been provided, the motion to set aside the default and or the stated proceedings is denied. How much is owing?
Your Honor, actually, Miss Givens, I believe yesterday dropped off certified funds to cover the judgment amount, and the day before that, she dropped off a check to pay the March charges. So she's current at present.
Ms. Gibbons, is all of that correct?
That's correct.
All right, then I guess the best way to do this is I'm just going to indicate the judgment was satisfied. And there's no reason for me to on your motion. You're all set, Ms. Gibbons. Thank you.
Judge, the reason why I was bringing it before the court was just I was actually seeking a waiver of the court fees. I paid them in order to avoid further escalation and a risk of eviction. But I still do not actually agree with the application of the court fees due to incorrect filing of the original demand for possession and how it went from there. And I've sought to work with.
What do you mean, ma'am?
I'm not sure if you saw my letter, but
I did. I'm looking right at it.
Okay, great. Where I just explained on the original demand for possession, it states an incorrect amount and it all incorrect amount owing. And then on the complaint, non-payment of rent, the amounts are also incorrect, and it also has an incorrect rent is paid through date. So there are just a series of clerical errors, perhaps.
Ma'am,
Yes.
when I'm looking at the document that you highlighted that you filed with the court, you're saying on January 22nd that on that date, rent was paid through November 30th of 2023, right?
Right.
And then after they signed the complaint, they then all arrears you indicate were paid January 24th.
Yes. Except for the court fee, because I wasn't sure about because I was confused on the first document that I got was not correct, and I was trying to clarify what amount I owed and whether or not they had cashed my check. And at that point, I explained in the fourth paragraph that their cashing of my check was delayed, and also for it to show up in my ledger was delayed about a month and a half. So they really didn't have record on their end of me paying even November's rent. So that reflected in my account and showed just an incorrect amount owing. So there really wasn't a way for me to bring the full payment because there was an incorrect amount listed. So it was just a series of clerical failures on SIO Farms end, on top of, I also, as I stated, had some late payments, but I acknowledged that and was working to bring those current, which I have. But so my only dispute was just if I could possibly waive that that February late fee and then the court fee, which I don't feel was filed in accuracy. And I feel that they delayed cashing of my November rent and also did not have knowledge of it until the middle of January. So,
right,
as far as their records.
But the very fact that happened didn't affect the court costs. There were still amounts owed when they signed the complaint.
Right, but in the initial filing had information on it that was not accurate.
Which initial filing?
The demand for possession, non-payment of rent.
Okay, but
13th.
ma'am, here's the problem. The problem
Okay.
is, at the time that they signed the complaint, did you owe monies?
Yes.
Then, and then at that point, they're entitled to their court cost.
Right, but I do understand that's how that works, but the information that they have listed at the very time of their signing was not correct. and on all of their documents.
But it wasn't
So-
zero.
Mhm.
If it had been zero and you didn't know anything and they said you owed something, then I can understand what you're saying, but it wasn't zero. You still owed something.
Okay. All right, that's what I wanted to find out and clarify with you.
Alrighty, thank
And Your Honor,
you.
if, just to clarify for the court, my client explained this to Ms. Givens. I personally explained this to Ms. Givens during a very lengthy phone call and explained to her exactly what Your Honor did, that there was court costs were still going to incur because balances were still owed to the landlord. And so I let Ms. Givens know when she reached out earlier this week that my client did not view her motion to have merit, and we would be requesting actual attorney's fees and having to address this matter yet again after it was explained to her more than once why those court fees were proper. And the fact that we had to come before the court to have it addressed yet again, I let her know that I would be requesting those actual attorney fees and having to address this. So I made that motion to Your Honor today to award those actual attorney's fees.
Okay, I am going to, it's a close call on it, but I'm going to deny the actual awarding of sometimes. And Ms. Gibbons understands something very closely. That I understand that Ms. Dornbush doesn't represent you, but you involved her in a conversation. You involved me in a very long conversation just now, and that's fine. But this had already been explained to you. And it was the same result. This time I'm going to just, sometimes people like hearing it from me. So I am just going to let it slide this time, but I have a very long memory. So
Thank
I'm
you, Your
going to deny plaintiff's request for actual attorney fees. Thank you.
Judge.
Thank you, Your Honor.